turn our attention to the third case on this morning's docket. That is case number 114752 in the matter of David Hardy.
May it please the Court, Deputy Disciplinary Administrator Michael Serra appearing for the Disciplinary Administrator's Office. Mr. Chief Justice, with the Court's permission, I would request to reserve 2 minutes for rebuttal.
2 minutes is granted.
Thank you. As the Court is aware, this is another original action in attorney discipline. This was a result of the respondent's felony conviction for driving under the influence of alcohol. The parties entered into a joint stipulation that the respondent had properly notified our office, and a hearing was conducted on August the 6th of 2015 on a formal complaint filed by Ms. Knoll. The panel concluded the respondent had violated KRPC 8.4b, result from the criminal conviction, and 8.4g. One aggravating factor was found in that the respondent had engaged in illegal activity. 8 mitigating factors were found, among which were the respondent's participation in treatment through his individual therapist and participation in the Kansas Lawyers Assistance Program. The respondent was also suspended indefinitely in the state of Missouri, where he's also licensed, but this is not a reciprocal discipline case. He individually reported his misconduct to both jurisdictions. It is my understanding the respondent is eligible for reinstatement in Missouri and is currently undergoing that process. However, given the nature of the charge and some other factors, it's my understanding that he had to retake the multi-state professional responsibility exam, which he passed. He is also having to undergo a new character and fitness examination by the state of Missouri, so his reinstatement there continues to pend. The panel and the Disciplinary Administrator's Office on this case recommended a 2-year suspension, but that it be made retroactive to the date that Mr. Hardy was temporarily suspended by this court. That would be January 7th, 2015. Given the evidence presented at the hearing and Mr. Hardy's continual improvement from his alcohol problem, that continues to be my recommendation today.
Any further presentation?
Not unless the Court has additional questions for me, Your Honor.
Questions? Thank you, counsel.
Thank you, Your Honor.
Counsel. John Ambrosio on behalf of the respondent. This is a fairly straightforward and simple case after some of the ones we've had this week. The respondent agrees and urges the court to follow the recommendations of the Disciplinary Administrator's Office and the panel. There is no doubt that this was a felony third-time DUI. The important thing is that his recovery is progressing in great fashion. He is in treatment and probably will continue to be in treatment and therapy for the rest of his life. He has expressed to me that that treatment and that therapy has helped him deal with alcohol, has helped him deal with family matters, has helped him deal with life. And he continues in that with a shrink, Dr. Davis, goes a couple of times. As a matter of fact, it's my understanding from talking to my client today, the Missouri Bar was absolutely impressed with how many times he sees his therapist. KLAP gives him great grades. He continues to work with KLAP. He continues to work with the monitor at KLAP, and McDonald and her staff are open to help this gentleman in any way possible. It is my understanding that he attends the resiliency group in Kansas City when he is able to, and is working his program as much as he can. It's an awful disease, but he is doing everything that he can. Also, I think it's important to understand that throughout this situation, throughout this process, he has never complained. He does not seem to be embittered about the fact that he lost his license because of the third-time DUI. He now works in a job, as I call it, an executive. He doesn't do any legal work at all, but he would like to get that license back someday so he can attempt to practice law. Without any further ado, if there are no questions, my client would like to address you, as this is part of his therapy and part of his recovery.
Counsel, would one of you tell us what you'd like for us to do in terms of resolving his case?
As I indicated, the panel suggested, and I go along with that, as does my colleague, that there be a 2-year suspension, but that it be retroactive back to the time you temporarily suspended him. If I didn't make that clear, I apologize. I thought I did right at the beginning.
And that is to be served, not suspended.
Correct.
That's what I need
Correct.
clarification.
Because of the felony conviction, I think he has to serve that.
Very well.
Thank you.
Thank you.
He's very nervous. This is very difficult for him.
Hi, my name is David Hardy. May it please the court. Over the last 3.5 years, I've learned a great deal about myself and alcoholism. I learned that the first step in recovery is acceptance that I'm an alcoholic. But more than that, I learned the first step in dealing with life's ups and downs is accepting what I cannot change. It seems very simple, but for me, it was a difficult obstacle. I learned to properly accept life on life's terms. I need hope. I hope that tomorrow will be better and that today is not the end of the world. I also learned that hope without faith is really really no hope at all. And that faith is that God is with me and that He's bigger than some of my biggest problems. When I accept life on life's terms, I can be grateful. I'm grateful that I don't drink. I'm grateful that I didn't hurt anybody. I didn't injure anybody on the day I was arrested. I'm grateful that for the change that began on the days after I was arrested. Leading up to 2015, I was very pleased with my progress in therapy and steps in recovery. I earnestly endeavored to figure out why I'd become an alcoholic and how I could manage it. I was not bitter about the punishments associated with my crime, but rather very pleased that I had the opportunity to start to put it behind me. I had come to full acceptance of my condition, and I believe strong sobriety was the result. On January 14th, 2015, my wife and I learned through ultrasound that my son Miles, our third child, had significant markers for genetic abnormality. After genetic testing came back normal, we were left with no answers. In late February, we were given very little hope that our son would even live, even if Children's Mercy was able to use extraordinary measures. And on April 11th, he was born, but died shortly thereafter. All of my life experience to that point could not prepare me for the pain that I felt with his prognosis, with his life, and then of course with his death. And I really don't have the words to express my feelings about his life, but what I can say is that through it all, my faith, my hope, the cornerstones, I believe, in my recovery are even stronger today. And I don't have any real explanation for that, but for God. I believe I'm a better person today than I was 4 years ago. I believe I'm a better dad and a better husband. And I think on the same token, I'll be a better lawyer as a result. Thank you.
Any further presentation from either of you?
No, Your Honor.
Okay, do we have any questions? Thank you both.
May it please the court, Mr. Chief Justice, I really don't have anything additional to present unless the court has additional questions for me at this time. If not, I would waive rebuttal.
I see no questions. Thank you, counsel.
Thank you, Your Honor.
We thank you all for your arguments this morning. Court will take this matter under advisement